station. It's going live.
A delightful, healthy, and warm good morning to everyone present here. I, UV Agarwal, along with Astuti Dwivedi, welcome you all to the close of the second Ambedkar Memorial Lecture 2023. What adds to the prestige of this lecture today is the significant date of this organization, 26th January 2023. It stands at the 74th Republic Day of India and holds eminent significance for all Indians. To commemorate and add to the glory of this day, we are blessed to have with us Honorable Mr. Justice Deepak Gupta, former Judge of the Supreme Court and former Chancellor of HNLU, who will be delivering the second Ambedkar Memorial Lecture 2023 today. I request Honorable Vice Chancellor Sir, Professor V.V. Vivekanandan, to kindly felicitate our Chief Guest with a welcome bouquet.
We also have Honorable Mr. Justice C.B. Bajpai as our guest of honor, who is the former judge of the High Court of Chhattisgarh and the former Vice Chancellor in charge of HNLU. I would request our respected Registrar, Professor Uday Shankar Sir, to felicitate our guest of honor with a welcome bouquet. Further, we have our Honorable Vice Chancellor, Professor Dr. V.C. Vivekanandan, along with our respected Registrar, Professor Uday Shankar, marking this occasion with significance through their presence. I further acknowledge the presence of the Deans of HNLU, the learned and respected faculty, staff, and students of HNLU. I welcome all of you to this day and this lecture.
Moving on to the main discussion on the floor today, the lecture series, as you have all understood, stands on the name of Dr. Babasaheb Bhimrao Ramji Ambedkar. He was not just an Indian jurist or politician, but was a social reformer, economist, educationist, and popularly known as the chief architect of the Indian Constitution. He dedicated his life towards eradicating untouchability and other social inequality in India. Born in Madhya Pradesh, he came from humble beginnings, but went on to become one of India's greatest leaders. His ideas about the state, society, and the possibilities and pragmatics of justice for the marginalized shaped modern India in profound ways. He was a formidable political force in the late colonial and early post-colonial periods. The Ambedkar Lecture Series seeks to honor Dr. Ambedkar's intellectual contribution to the world by exploring his ideas and values and bringing together students, academicians, and jurists from various backgrounds to reflect on Dr. Ambedkar's scholarship in various fields and its relevance in the present world context. This lecture today will mark the second celebration of the said etiquettes.
I shall now invite Honorable Vice Chancellor Professor V.C. Vivekanandan to deliver the opening remarks. Professor Vivekanandan, the renowned academician and administrator, has 3 decades of teaching and research experience in legal education, particularly IP and Internet law, and has also served the National Law School, Bangalore, and Nalsa University of Law, Hyderabad, between 1990 and 2017. He was the Dean of Rajiv Gandhi School of IP Law at IIT Kharagpur between 2009 and 2010, and was the founding Dean of the School of Law at Bennett University at Greater Noida during 2017 to 2019. At NALSA, he also served as the MHRD Chair Professor. He was also the convener of the Common Law Admission Test 2022. At HNLU, Sir has been spearheading numerous initiatives aimed towards ensuring that HNLU makes a mark in the international legal community. Sir, may I now request you to address the opening remarks.
Honorable Justice Sri Deepak Gupta, former Judge of Supreme Court of India and former Chief Justice of High Court of Chhattisgarh, former Chancellor of HNLU. Honorable Justice C.B. Bajpai, former Judge of High Court of Chhattisgarh and former officiating Vice Chancellor of HNLU. Faculty colleagues, staff, students, distinguished guests, and the press. I welcome both our chief guest and guest of honor on behalf of the HNLU fraternity for today's memorial lecture. It's a great beginning today on the Republic Day to hold the second Dr. Ambedkar Memorial Lecture named on the architect of the Indian Constitution, which laid the foundation of Indian Republic, and this day is celebrated, marking that historic beginning of our great nation. Today is not just a day of ritualistic fervor of celebrating the Republic Day, but a day to introspect, to reaffirm our faith in the values and the spirit of our Constitution, which guides every aspect of our life. It is pertinent to remember Dr. Ambedkar's caution. I quote, "So long as you do not achieve social liberty, whatever freedom is provided by the law is of no avail to you." I close the quote. In this context, this memorial lecture is an apt event for us to revisit and reaffirm what this day and the future stands for us. I need to say a few words on Honorable Justice Shri Deepak Gupta, apart from the formal introduction, which will be done when he speaks. My interaction started with him once I was appointed by meeting him in his residence in New Delhi sometime in the second week of September 2019. Within few minutes of formality, he moved to the brass tacks and started discussing what needs to be done at HNLU. And I felt confident that I am under the requisite care and mentoring from him as our former chancellor and the council member at the time. Thereupon, we had few interactions and also a visit to HNLU in December 2019 and later also in Delhi during the conference done by the Honorable Chief Justice of India, where he was also speaker. His support has been great, and I've been interacting with him all these days, even during pandemic times. And it was his promise that he will visit HNLU. And when I flagged this issue about memorial lecture, I was a little hesitant about his time and engagement. I did use the very diplomatic way, offline/online, and immediately I got a WhatsApp message within a few minutes that I'm coming over physically. And so that's why we have here. And Honorable Justice Mr. Bajpai was my predecessor who held the rudder of this ship in tumultuous times of a vacuum in leadership. And he has been a guiding and meeting me whenever we have some issues with his same advice, and has been kind enough to be present today, driving all the way from Bilaspur to attend this function. Thank you very much, sir. The theme of the memorial lecture chosen by Justice himself. We are eager to know his thoughts and interpretation as a jurist for many decades, which should have given him a close introspection than academics like us who deal more on theoretical aspects. I would like to share a few points of my introspection on this topic, which is going to talk as a kind of curtain raiser. I am never tired of this quote, so I keep repeating it. The quote is by the academic in an article called Portia Lost in the Groves of Academia, Wondering What to Do About Legal Education, is the article's lengthy title. And the quote goes like this: law is at the intersection of the ideal and the real, of metaphysics and magic, of the actual and the possible, of the ideas and power, of fact and value, of ease and ought, of the past and the future, of the individual and the social, of the economics and political. I consider this equals to 10 PhD theses. What we can talk about legal education, law, what we are doing, and what the judges are doing in the court, and the public at large, looking forward towards to realize their values. So the topic today chosen by Honorable Justice is the will of the people or the rule of law. The will of the people and the rule of law are important principles in democratic societies. The will of the people is reflected in the democratic process through which the citizens elect representatives, make decisions through a majority vote. The rule of law is the principle that all individuals and institutions are subject to the law and that law is applied equally and fairly. In a functioning democracy, the two principles work together to ensure that the government is responsive to the needs and wants of the people, while also ensuring the rights of the minorities and the individuals are protected. At least three postulates, in my opinion, should be borne in mind in understanding these twin postulates of will of the people and the rule of the law. The first one is the power is with the people to decide about the destiny and destination which is channeled through the legislature in any electoral process. And that's why the Constitution starts, we the people give it to ourselves. Secondly, the legislature and executive, as a continuum of such power process, translates the will of people into a structured route called rule of law. Thirdly, the working of the rule of law and its audit is entrusted with the judiciary. At least these three minimum postulates in a way will explain about the concept of will of the people and the rule of law. In practice, such theoretical postulates often run aground. Where it runs aground, number one, the will of the people at times can be against the minority. What we call tyranny of the majority may prevail. So, what is this will of the people? Is the will of the people is monolithic, or the will of the people has shades within that? That is a very, very crucial and important point of our governance. Here it is a challenge to the rule of law to set it right. If such will of the people is presumed to be a tyranny of the majority. Second, in another context, the rule of law can also run against the will of the people by often quoted the American tradition called judicial activism or judicial review, where it can be pitted against the legislature. Judiciary can be pitted against legislature. And I need not much explain this if you are all reading newspapers, right? So this could be another way of looking at this topic. Now, in both these type of situations, the compass of the right direction is actually that of the Constitution and its fair interpretation by the judiciary. The flashpoint in many constitutionally sound democracies is that the two guardians of power, the government acting on behalf of the will of the people, and the judiciary, which is a guardian of the rule of law, often can come to near collision or collision courses. Speaking of the government holding the power on behalf of the people, one needs to remind the famous quote, power tends to corrupt, and absolute power corrupts absolutely by Lord Acton, expressed in his letter to Bishop Mandel Creighton in 1887. Power connotes, in a simple meaning, the ability to do things. But the moot point is how much power is generated in the governance, how it ought to be exercised, and the need and necessity of distributing such power and the analysis of such separation between one arm, which I call the government, even though I consider executive by and large aligned with legislature in throughout history in many places. On the other side, the most independently looked judiciary is a crucial point. This is not today, it is since Greek times. On the flip side, the judiciary guarding the rule of law needs the art of balancing its role in its act. As a procedural doctrine, activism is a kind of thing which we need to look at, restraint, which urges judges to refrain from deciding legal issues, and especially constitutional ones, unless the decision is necessary to the resolution of a concrete dispute between adverse parties. As a substantive part, it also urges judges considering constitutional questions to grant substantial deference to the views of the elected branches and invalidate their actions only when constitutional limits have clearly been violated. In the words of late Aaron Barak, a professor as well as a judge of Israel Supreme Court. I quote, the task of accommodating such a judicial review with democratic governance is inherently problematic. Within a system of free government, the court fulfills an important but yet a limited role as an auxiliary precaution against both the abuse of the governmental power by a tyrannical majority or a minority and the excesses of majoritarian democracy. He further observes judicial review becomes controversial only when the court thwarts the effort of the will of the people or goes too far and too fast with its construction of the constitution. Judicial aggression in constitutional politics could be lamentable and objectionable if it occurs. Yet, far from being antithetical, judicial review is essentially to the promise and performance of the free government. To conclude my remarks, the will of the people is supreme, in my opinion, and it originates akin to the origin of a river starting somewhere. But the river's path, a civilized path of flowing and nurturing life as it flows in a terrain, what we call society, is set by the rule of law. Often such a flow is not a predetermined one, but often leads to flash floods, avalanches, and other consequences. The art of democracy in the canvas of a nation is determined by two brushstrokes. One is will of the people and the rule of the law. And more to paint on this, we may be looking forward to today's speaker in his memorial lecture. Thank you.
Thank you for those informative words, sir. We would like to request Honorable Justice C.B. Vajpayee to address the audience and enlighten this event. Honorable Mr. Justice C.B. Vajpayee was the additional judge in the High Court of Chhattisgarh from 27 January 2014 to 13 October 2017. Justice Vajpayee has served as the President of Chhattisgarh State Consumer Disputes Redressal Commission from 9th October 2018 to 13th October 2022. During his tenure as the chairman of the Chhattisgarh State Dispute Redressal Commission, he was invited by the then Chief Justice of High Court of Chhattisgarh and Chancellor of HNLU to officiate as the in-charge Vice Chancellor of HNLU between 3rd October 2018 to 10th September 2019. During his tenure as the then in-charge Vice Chancellor, he was instrumental in implementing significant measures to steer the university administration. He handed over the charge of Vice Chancellorship to our current Vice Chancellor, Professor Dr. V.C. Vivekanandan. I invite you to address the gathering.
Honorable Mr. Justice Deepak Gupta ji, former Judge Supreme Court of India, and our Chancellor, Honorable Professor Vivekanandan ji, Vice Chancellor, HNLU, Registrar Mr. Uday Shankar ji, Honorable faculty members, staff, our students of HNLU. We humbly request Honorable Mr. Justice Deepak Gupta ji to enlighten us on the topic will of the people or rule of the law. As scheduled, I am putting my remarks on the topic. The rule of law is a principle that holds that all individuals and institutions that are subject to and accountable to the law, which is fairly and impartially applied and enforced, which is based on the idea that no one is above the law and that everyone should be treated equally under the law. The term law and order is gotten from the French expression law principe de legalite, the standard of legitimateness, which alludes to an administration in view of standards of regulation and not of man. It likewise implies that power ought to be practiced inside the legal ambit and employed exercise of it couldn't simply be ultra-virus, yet from a genuine perspective of term inconsistent. The rule of law is a term that is often used but difficult to define. A frequently heard saying that the rule of law means the government of law, not man. But what is meant by a government of law, not man? Aren't law made by man and woman in their role as legislature? Don't man and woman enforce the law as police officers and interpret the law as judges? And don't all of us choose to follow or not to follow the law as we go about our daily lives? How does the rule of law exist independently from the people who make it, interpret it, and live it? Presently, the concept has altered into a new corollary stating that the holders of public power must be able to publicly justify that the exercise of power is legally valid and socially just. It is the present day modernized name for natural law in jurisprudence was known as jus naturae by the Romans, law of God, and medievalists. Coming ahead at times, Rousseau, Hobbes, and John Locke called it social contract or natural law. The modern man refers to it as a rule of law. The will of the people, also known as popular sovereignty, is the principle that the authority of a government comes from the consent of the governed. It holds that power of a government is derived from the people it governs, and that the government's action should reflect the will of most of its citizens. Both the rule of law and will of the people are important principles in democratic societies, as they help to ensure that the government is accountable to its citizens and that the right and freedoms of individual are protected. Two concepts are closely related, as the rule of law helps to ensure that government action aligns with the will of the people. Any state committed to democracy will have immense reverence to the rule of law. Rule of law ensures stability, structure, and most importantly, restricts the arbitrary distribution of power and control. For example, in India, the Constitution, Part 3, in particular, governs the law passed by the Parliament and ensures that such law in existence and henceforth passed, which are violative of or abridge fundamental rights, can be declared void. The Indian Constitution establishes a limited government. Being a federal country, both the central and state legislature has the power to make law, but only subject to express and implicit constitutional limitations. First of all, the Constitution specifies and demarcates the matter on which the central legislature and state legislature could make law. Any law that breaches these limitations could be declared unconstitutional by courts. Despite several provisions in place reflecting conceptualizing rule of law, the exact word rule of law are not found in the Indian Constitution. Idea of rule of law got amplified through the judicial interventions in numerous cases, such as celebrated judgment of Keshwanan Bharti, Maneka Gandhi, Indira Nehru Gandhi, and others. These judicial pronouncements are advancing the vision of the constitution makers who resolved to follow the mantra of equality before the land and absence of arbitrariness in the state action. The framers envisioned an India that is free, open, and democratic, rid of arbitrary power and ineffectual existence of rule of law. The rule of law is more of an ideal that we strive to achieve, but sometimes fail to live up to. The idea of the rule of law has been around for a long time. Many societies, including our own, has developed institutions and procedures to try to make the rule of law a reality. These institutions and procedures have contributed to the definition of what makes up the rule of law and what is necessary to achieve it. Hence, whenever there will be a loggerhead between will of the people and the document given by the people to themselves, people will be bound by the document, and a popular idea of majority of people cannot override the constitution as per majoritarian whims and fancies. The highest court in B.R. Kapoor versus State of Tamil Nadu was declared that the constitution prevails over the will of the people as expressed through the majority party. The will of the people as expressed through the majority party prevails only if it is in accord with the constitution. The constitution mandates that every institution must commit to the rule of law, and every citizen bestows respect to the rule of law and resists the rule of man. Thanks for the opportunity given to me to submit few remarks on the topic. Thank you again.
Thank you, sir, for those precious words. Today, on this auspicious occasion of the 74th Republic Day, we have gathered to celebrate the life and legacy of Dr. B.R. Ambedkar. It is now time to have Honorable Mr. Justice Deepak Gupta bless us with his words. Justice Deepak Gupta graduated in 1978 from Campus Law Center, Delhi University. He practiced constitutional, civil, and corporate law matters in Himachal Pradesh High Court for 26 years. He also served as the counsel for Himachal Pradesh's Road Transport Corporation, Housing Board, and New India Assurance Companies. He was an elected member of the Himachal Pradesh High Court Bar Association in various capacities as the secretary, as the vice president, and as the president. In October 2004, Justice Gupta was elevated as a judge of the Himachal Pradesh High Court. He served as the president of Himachal Pradesh Judicial Academy and the chairman of Himachal Pradesh's State Legal Services Authority for nearly 4 years. He was in charge of the digitization initiatives of the Himachal Pradesh High Court, overseeing the computerization of courts and developing e-court modules. Justice Deepak Gupta was appointed as the first Chief Justice of the Tripura High Court on March 23, 2013. He was appointed as the Chief Justice of Chhattisgarh High Court on May 16, 2016. Since his elevation to Supreme Court in February 2017, Justice Gupta has authored 139 judgments as a Supreme Court judge. On May 6, 2020, he retired from the Supreme Court. Sir, it is indeed an honor to have your august presence among us. Without further ado, I now invite you to deliver the second memorial lecture 2023 on the topic of Will of the People or the Rule of Law.
A very good morning to you all. Honorable Mr. Justice C.B. Bajpai, former judge of the Chhattisgarh High Court and former chancellor of this university, and my neighbor in the judges' colony in Bilaspur. He has encapsulated what I wanted to say, which I'll take 40 minutes to say. He has done it in 2 minutes. And if I was to write a judgment, I would have said, I agree, and signed it and sat down. But then your vice chancellor would not be happy. Dr. V.C. Vivekanand, vice chancellor of the HNLU. First of all, let me congratulate you for what I've seen last evening and today. I see a lot of improvement in the from where I went to. Please keep up the good work. There's lots more to be done. Also, the same to the registrar and faculty members, members of the media who are present here to spread the word, and foremost, my dear students. If you will remember, probably I was the only chancellor who went to the boys' mess and had lunch with you. Today, we are celebrating the 74th day of India becoming a republic. It is a very, very important day. For this, it is on this day that the constitution, which was adopted on 26 November 1949, was formally enforced and we became a republic. I have structured my addressed in 4-5 portions. I'll deal with the will of the people, with the rule of law, the conflict between them, and in present day circumstances, I will also deal with the basic structure of the Constitution and the collegiate system. Because I really believe to catch the bull by the horns, जो चीजें अखबारों में आ रही हैं उसके बारे में ही बोलना चाहिए. Why should we try to hide and say we will not talk about it? I am extremely grateful to you, Professor Vivekanand, for inviting me to deliver this lecture, the second B.R. Ambedkar Memorial Lecture. It's a proud privilege to be associated even with the name of Dr. B.R. Ambedkar, who was the architect of our country. However, before addressing on the main topic, I would like to talk about two personalities. One is Justice M. Hidayatullah, after whom this university is named, and the other is obviously Dr. B.R. Ambedkar, after whom this lecture series has been instituted. Justice Hidayatullah was, without doubt, one of the greatest judges in this country. He was not only a jurist par excellence, but he was also a linguist. He was a poet of sorts. His father was a very great Urdu poet, but he was also not a mean poet. He was, I think he knew 7-8 languages, including Sanskrit, very well. He belonged to Raipur. He had his schooling until the primary level in Raipur. And then he went to Nagpur, went to Trinity College, London, where he obtained a degree in economics and was called to the bar from Lincoln's Inn. He practiced at the High Court of Central Provinces and Berar, which later became the Madhya Pradesh High Court, and was elevated as judge there, and later elevated as Chief Justice of that court. He came to the Supreme Court in 1958, and became Chief Justice of Indian System. And while serving, he has a unique, I think many of you may know it, because recently I saw this also in Bar and Bench or Live Law. There's a question that he was the one Chief Justice who served both as acting Vice President and acting President of India. And he actually was later elected to be Vice President of India. The President has a house in Simla near Simla called the Retreat. And all presidents normally come to Simla for a few days in the summers. And they allow the Vice Presidents all to use their residence. So Justice Hidayatullah used to come there very often. I was a fresher at the bar, but I was normally an office bearer or a member of the executive committee. And all these years I interacted with him. And whenever we invited him to deliver a lecture at the Bar Association or some other occasion, he would always do so. I've had some wonderful conversations with him. And coming back to the Hidayatullah National Law University brings back memories of my interactions with him. He never made me feel that I was a fresher at the bar. He would talk to you on a one-to-one basis. Today, on the 74th Republic Day, I, as a student of law, pay my humble tributes to Dr. B.R. Ambedkar. He also known as Baba Sahib. He was born on April 14, 1891 in Mount in Madhya Pradesh. He was the 14th child of Ramji Sakpal, who was a Subadar in the British Indian Army. Subadar was a fairly high post at that time. Very few Indians reached that post. So Dr. Ambedkar did not belong to a poor family. Let's be honest about it. But he belonged to the Mahar caste. So he was an untouchable, which was worse than being poor. And for a person belonging to the Mahar caste to even aspire to be educated, let alone we reach the level that Dr. Ambedkar did, was something very difficult. But he was made of sterner stuff. And he not only studied, he studied in Bombay, went to Columbia in New York, obtained his doctorate from there, then went to the London School of Economics, obtained another doctorate from the London School of Economics, attended Gray's Inn and was called to the bar from Gray's Inn. After he came back to India, the Maharaja of Baroda appointed him as advisor of defense, which was almost like a post, a ministerial post, a very high post. He did reach a high post, but his colleagues, who all belonged to the high caste, did not even interact with him on a social level. They humiliated him whenever they could, and therefore he left that high position and turned to practice of law. But law was not his only calling. His main purpose in life became to become the voice of the untouchables. He also was a freedom fighter and published various journals advocating political and social rights of the underprivileged and the downtrodden. These two giants of the legal fraternity, Justice M. Hidayatullah, Dr. B.R. Ambedkar, came from two totally diverse backgrounds. One from an aristocratic Muslim family, which was full of riches, and one, the son of a Subedar, belonging to an untouchable class. But this is the beauty of our nation, even in pre-constitution days, that both could achieve these high posts they did. But obviously, the credit has to go to their own merit. Then in 1947, we attained independence. It was decided to form the Constituent Assembly to draft the Constitution. No civilized country in the world can exist without a written Constitution. But we have one. England has no written Constitution. But they have a lot of, they believe in customs. They believe in history. They believe in precedent. Therefore, they've never, even without a written Constitution, they've done a wonderful job of doing it. So when this Constitution, Dr. B.N. Rao was appointed the advisor to the Constitution, Constituent Assembly, and he presented a draft Constitution, which was based on the 1935 Government of India Act. Now, then you had 200 odd, almost 280 or 280 some members of the Constituent Assembly. 280 something, and 233 were high caste Hindus. That was the. So you had a high number. Now you couldn't discuss it, so a drafting committee was constituted, which consisted of the best legal brains of that time, including Naladi, Krishnaswamy Iyer, and so on. But the president of the Constituent Assembly, Dr. Ambedkar Prasad, appointed Dr. B.R. Ambedkar as the chairman of the drafting committee. And he did a wonderful job as the chairman of the drafting committee. No better compliment can be paid to Dr. Ambedkar than what Dr. Ravinder Prasad himself said, and I quote, "Sitting in the chair and watching the proceedings from day to day, I have realized, as nobody else could have, with what zeal and devotion the members of the drafting committee, and especially its chairman, Dr. Ambedkar, in spite of his indifferent health, have worked. We could never make a decision which was or could be ever so right as when we put him on the drafting committee and made him Christian." So this was the acknowledgement by his peers, by Dr. Ravinder Prasad. Now, what was Dr. Ambedkar's contribution? There was a lot of thought at that time. Should we have one man, one vote, or one woman, one vote? We got one person, one vote. I'm trying to be gender neutral. One person, one vote in 1950. There are many advanced countries, including some cantons in Switzerland, which got this only in the 2000s or the late 1990s. And women were not entitled to vote in these so-called advanced and civilized nations till as far back still as far back as 25 years. So he was a great voter of the universal adult franchise. He was also a great votary of ameliorating the sad situation faced by the scheduled castes, the scheduled tribes. Some things are best said in the words of men, in the way they feel, and I quote Dr. Ambedkar. When he said, when the Constituent Assembly was ratifying the Constitution on 26 January 1949, and I quote, "We are going to enter a life of contradiction. In politics, we will have equality, but in social life, we will have inequality. Because you may give a vote, but you won't marry your son to the untouchable. In politics, one man, one vote, and one vote is equal to one value. But in a social and economic structure, continue to deny the principles of one man, one value. How long shall we continue to live this life of contradiction? How long shall we deny equality in our social and economic? I just ask you to look within yourselves. Have we even today achieved or anywhere near what was Baba Sahib's dream? I don't think so. He was also well aware that giving votes to everybody is not going to be the final solution. I am of the view that the men and women who drafted the Constitution, they were not bogged down like our present day politicians with vote bank politics. They had no communal thought. They had no caste-based thought. They never thought कि मैं हिमाचल से belong करता हूँ, कि मैं छत्तीसगढ़ से belong करता हूँ, कि मैं चेन्नई से belong करता हूँ. They never thought of the province, the village, the state. They thought only of the country. And if all of us think only of the country, things cannot go wrong. They go wrong because we think not of the country, but of other things first. Constitution of India is a very, very long document. It is one of the most finely crafted constitutions in the world. Our Constituent Assembly took ideas from Ireland, from France, from America, and you probably can't find a better constitution. But the heart and soul of the Constitution is encapsulated in the preamble of the Constitution, which I find also embedded on the entrance of the instrument. And it bears repetition each and every day. And I will repeat it before you. We, the people of India, have been solemnly resolved to constitute India into a sovereign democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, that's brotherhood, assuring the dignity of the individual and the unity of the nation. The words socialist, secular, and integrity were added by the 42nd Amendment. I'm not dealing with them because let's deal with what the founding fathers or mothers said at the time when the Constitution was drafted. Now, what did we promise ourselves? Justice, liberty, equality, and fraternity. ये चारों चीजें एक अलग-अलग नहीं चल सकती. They have to move together. There can be no justice without equality. There can be no justice without liberty. There can be no justice without fraternity. And if you tag one to the other, they all have to be read together. Now we come to the will of the people. And there can be no doubt, as Dr. Ambedkar said, that the will of the people is supreme. But what is the will? Recently, as I've said, a lot has been said of the will of the people, especially with regard to the basic structure of the regime, and come to that later. We are a country which has elections every 5 years, and sometimes much faster because of political category. We have more elections than are called for, and we elect our representative to represent us in the state legislature as well as in parliament. We follow one vote, one for every person. That is as constitutionally follow. But we have a system which is the first past the post system. That means that the person who gets maximum number of votes polled gets elected. I'm not criticizing the system. Please understand, I'm not criticizing the system. In fact, my belief is this is the best system we can. But does this system ensure that the representatives of the people who are elected to govern us according to the Constitution represent the will of them? Because we are dealing with what is the will of them. You will see that almost none of the candidates get 50% of the votes. Polled. Somebody gets 30%, somebody gets 40%, but because there are 10 candidates, 5 candidates, 6 candidates, and they get elected. So 70% people have not voted. And look at another factor. In our country, average polling is only about 60%. 50 to 60, 65%. So 2/3 of the people don't even vote. I have got the figures for the last 2 general elections, and the ruling party in the central government got 37% votes in the 2019 elections and 2004 and 31% votes in the 2014 elections. So they had one third of the votes polled. And if you take them to if you extrapolate this number to the total number of the eligible electorate, it will be less than 25%. Please do not say that. I'm not at all saying they are not elected to represent us. They are our representatives. They have been given the constitutional mandate to govern. But can they claim that they are the will of the people with less than 25% of the vote? Then another aspect is that we never fight elections. Unfortunately, we never fight elections on policy, whether economic, social, political policies. We fight elections on vote bank basis. We fight elections on communal basis. We fight elections on regional basis. We fight election on caste basis. We promise swaps and freebies to the voters. Have you ever read? कभी आपने सुना है कि कोई इलेक्शन के टाइम पे कैंडिडेट बात करता है रूल ऑफ लॉ, will of the people? Does any candidate talk of the collegium system, of the basic structure of the constitution? Now, when these issues are not before the electorate, and the electorate is voting whether every woman should get 2,000 rupees, whether there should be a laptop for every student, and how we will govern, then where is the will of the people to say that we will change the basic structure of the constitution? Now, for me, I am very clear that the elected representatives who are elected to govern do not represent the will of the people, and therefore my answer is an emphatic no. But assuming for the sake of debate, we are discussing things, assuming for the sake of debate that they represent the will of the people, then even if it is the will of the people, can it override the rule of law? That will be the second question. I have talked to you about the 4 rights of justice, liberty, equality, and fraternity. And in my view, every law which Parliament passes has to be in sync with what is said in the preamble of the Constitution, because that is the heart and soul of the Again, I can do no better than quote Dr. Ambedkar. Normally, I'm known for not quoting many people in lectures or even in my judgments, but here I can do, there are some words which he has quoted so well that I can't do better. He says, these principles, this is I quote Dr. Ambedkar, these principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. ये Brahma, Vishnu, Mahesh नहीं है. They are together one entity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. So if you talk of equality, you have to talk of fraternity, of brotherhood. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few and the many. Equality without liberty would kill individual initiative. Without fraternity, liberty, equality would not become a natural course of things. It would require a constable to enforce. Police ka danda chahiye hoga if you want to enforce when you fraternity, if you don't talk of equality. You are all students of law. Some of you are teachers of law. But anybody in the legal fraternity always remains a student. The minute you think that you know the law, you cease to be a member of the legal fraternity. Because it's such a wide campus spectrum that none of us can ever say that even we know 1/100th of the law. But one thing is very clear, that we have a system of separation of powers. The separation of powers between the legislature, the executive, and the judiciary. These three wings have been created as a system of checks and balances. And the system can work when each wing respects the other, when each wing does not encroach upon the other. No wing is supreme. Neither the Supreme Court of India is supreme, nor Parliament is supreme, nor the Government of India is supreme. What is supreme? What is supreme is this, the Constitution. My old feather-bound Constitution, and I can tell you, now this is not part of my lecture, but I'm telling you, I think Mr. Vajpayee has seen it. On my table, from the day I became a judge, I have the plaque with the preamble to the Constitution on my table. And whenever I've had difficulty deciding any case, I read that preamble again and I see how it fits into the case. And I've always found the answer in the preamble. That's how it works. Now we come to what is the rule of law. You must understand what is the rule of law before you have a discussion. Aristotle, you all know, he was a great Greek philosopher. He wrote, law should govern. So it should law and not men who govern. The basic principle of the rule of law is that the state governs not in accordance with law and not according to the whims and fancies of men. It is very often said that even in ancient India, there was dharma, there was nyaya, and that rule of law is embodied in it. They were great rulers, and some of the concepts of nyaya and dharma are as good as any other in Western civilization. But please remember, the rulers were not themselves bound by nyaya or dharma. I'm not a very great fan of the Manusmriti, to be honest. But even when we talk of very good rulers, they could dispense justice very well, but not when it came to them, because they were always above the law, because they had divine rights. They claimed to be, all our rulers said they are descendants of Bhagwan Ram or Bhagwan Krishna. So how could they be under the law? In more than 1008 years back, as far as the civilized world is concerned, the very genesis of the rule of law came when the Magna Carta was signed in England on June 15, 1250. Now, what led to the Magna Carta? On one side was the church, saying the church is supreme. On one side was the king, who said, I have the divine right to rule and I am supreme. और इन दो पत्थरों के बीच में it was the citizens who were being crushed. So finally peace was brokered and the Magna Carta was signed. There are two articles of the Magna Carta which I want to read out before. And please listen to them carefully. And if you have time and the interest, then go to the library and read them again and think if better words could have been written. I quote Article 39 of the Magna Carta. It reads as follows. No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing. Please remember, deprived of his standing. I'm talking to you in the Indian context of untouchability and caste. In any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgments of his equals or by the law of the land. It virtually encapsulates what is said in Part 3 of our Constitution and Fundamental. Each and every fundamental right is in one article. But most important is Article 40 of the Magna Carta, which reads, and I quote again, to no one will be sold, to no one deny or delay rights or justice. These beautiful, stirring words, written more than 1,000 years back, is the reason why England, without a written constitution, still strives as one of the old democracies in the world. What does these mean? These words mean that everybody shall be treated equally. Nobody's rights will be taken away. Nobody's standing will be taken away, except in accordance with law. Now, the other development of the rule of law is when I think the first decision in respect of rule of law was given. The year is 1608. The place is still in England. We follow the Anglo-Saxon law. We have a colonial background. So good, bad, or worse, we have to go back there. The year is 1608, England. King James the First is ruling, and Lord Coke is the Chief Justice of England, the Royal Courts of England. Now, under Justice Coke, many administrative actions were being set aside by issuance of writs. So, King said, what is this happening? How can you do this? I am the ruler. I have the divine right to rule. How can you set aside my actions? And on 13 November 1608, he said, all the judges have been appointed by me. They are my delegates. So I have the right to withdraw any case from their court and take it up myself and decide it in the manner I want to. So before that, Coke had answered when this thing, Coke had answered and I quote, that the law is the golden bond and measure to try the causes of the subject, and which protected his majesty in safety and peace. So he says the law is what will govern the people, and the law is what will protect the king also. That means it is the law which protects the government and the law which also protects the people. King says nothing doing, I am not subject to the law. To which Justice Court said, and this is written in writing, it's a judgment, the king himself ought not to be subject to man. So the king, as king, you are not subject to any man, but you are subject to God and the law, because it is law that makes you. So where do we judges come from? They are appointed under the Constitution. Where the Prime Minister and the ministers come, they are also appointed under the Constitution. We are all creatures of the Constitution. We are not, we are all subservient to the Constitution. The Constitution is not subservient. So the rule of law implies that every citizen is equally subject to law. It stands in stark contrast to the idea that the ruler is above the law. The rule of law, I mean, it's a very wide concept. It's a dynamic concept. It keeps changing. But there are certain essential features. I'll just list them out hurriedly. One is the supremacy of it. The law is supreme. A concept of justice where some standards are laid. Restrictions on the exercise of discretionary power. Discretionary power, even Article 142 of the Constitution giving powers to the Supreme Court, must be exercised in a judicious manner. The doctrine of judicial precedent is part of the rule of law. Otherwise, you will keep changing the law. Otherwise, you will keep changing the law. So you have a judicial precedent. And laws should normally be prospective and not retrospective. You can't say today on 26th January 2022, something which is 23, which is something which is not an offense, you make it an offense on 27th January. So laws would normally never be. In tax and all, it's a different, but the laws relating to rights and criminal laws, they have to be. And independent judicial, I should be talking about this more, is an inherent feature of the rule of law. As Justice Bajpai said, the exercise by Parliament of the legislative powers and restrictions in accordance with the Constitution and the restrictions placed. And very importantly, an underlying moral basis for them. I think some of you must be aware of the judgments on constitutional morality given by Justice Dhananjay Chandruchud and Justice Rohit Nagmi. So there is also, we will introduce this, that they are in accordance with the spirit of the Constitution. So I'm just reading out a portion of my speech because this I don't want to change. In my view, the concept of rule of law implies that the laws must be framed in a manner that they do not impinge upon the human rights of individuals. All human beings should be treated equally. Once the law has been framed, it must apply with equal vigor to each and every person, which will include those who rule. The essence of the rule of law is that every authority is subject to and governed by law. The opposing idea is a state of affairs in which the will of an individual or a group, such as a political party, a majority, acts. Now, majoritarianism is very, very dangerous, as I will show you in a few minutes. When there is rule of law, there is fairness. And when there is no rule of law, there is arbitrariness. There is anarchy when there is no rule of law. Another very important aspect of the rule of law is judicial review of executive action and legislative function. Are the laws framed in accordance with the Constitution? Are the actions taken in accordance with the laws or the Constitution? And that is why there is the system of separation of powers. The right of fair trial is also part of the rule of law. All judgments should be published so that people know about them. And today, the Chief Justice of India is going to ensure that judgments are released in regional languages also. So it's very easy to say ignorance of law is no excuse. But as I said earlier, even we who belong to the legal fraternity don't know 99% of the laws. How can you expect a poor citizen to know all the laws? So you have to make it easy access to court is another important aspect of the rule of law. I mean, to put it very, very simply, I would say rule of law is to do something which is right, something which is honest, something which is fair, something which is truthful. If you follow these, then it is according to the rule of law, otherwise. Now comes the role of the judiciary. It is the duty of the courts to enforce the law. This is the duty enjoined upon by the Constitution. They do so not only by deciding disputes between citizen and citizen, but keeping in view the federal structure of our Constitution. They decide dispute between citizens and the state, between citizens and the union, between states and states, between states and the union. So it is more important that we hold the scales of justice even, and the judges must carry out their job without fear or favor, affection or ill will, to the best of their knowledge, ability, and judgment. This is the oath we all judges take, Justice Bajpai. But another aside, another secret which I may reveal. During my period as a judge, every time when I went for my morning walk, which was almost every day, unless I was unwell, I would remember I would revisit my oath early in the morning. I would not chant any mantras or anything. I would remember my oath. Because when, as you sit as a judge, it is this oath which is more important. It is this Constitution of India, which is my Gita. It is this Constitution of India, which is my Bible. It is this Constitution of India, which is my Guru Granth Sahib. It is this Constitution of India, which is my Quran, if I'm sitting and acting as a judge of a constitution. We are promised equality, justice, fraternity. And the courts are bound to ensure that these do not remain mere words in the Constitution. But all the citizens actually get access to the courts and are not denied what is due to them under the Constitution. The liberty of any citizen should not be curtailed without following the due process of law. See, the importance which Dr. Ambedkar and his team gave to the fundamental rights and to the right of the court is best reflected in Article 32 of the Constitution of India. Probably we are one of the few, if not the only country in the world, where the right to approach the highest court of the land, that is the Supreme Court of India, for enforcement of fundamental rights is itself a fundamental. So that is the importance we give. As a principle of governance, the rule of law, like democracy, and the separation of powers is an integral part of our body politic. It is the golden thread which runs and binds our constitution together. If we don't have the rule of law, then this constitution will not survive. You know, anytime, anywhere, even if I had a vote here in this hall, if we had a poll here in this hall, and you were asked to choose, I'm sure the choice would always be the same. Freedom, not tyranny. Democracy, not dictatorship. The rule of law, not the rule of men. The bedrock of our democracy is the rule of law. And therefore, it necessitates that we must have an independent and fearless judiciary. which is not cowed down by by anybody. There can be rule of law only if we have judges. You know, the oath says, the first word in the oath is without fear or favor. जब हम शपथ लेते हैं, without fear or favor. So the first word is fear. And unfluenced by any extraneous condition. A free country is one where there is freedom of expression and governance by the law. A free country is one where when a session attends, any one of you can get up and say, Justice Gupta, you were totally wrong. I disagree with you on this. And we can have a discussion. And we can discuss in a civilized manner. We can agree to disagree. That is the beauty of it. We don't have to fight and kill each other because we disagree with it. Violence is anathema toward democracy. When there is no sharing of power, no rule of law, no accountability, all that it will result is in abuse, corruption, subjugation, and indignation amongst the people. When the rule of law disappears, if the rule of law disappears, we will be ruled by the idiosyncrasies and whims of a few. Please, my fervent request to you, never let that happen. Now, recently the Honorable Vice President said that he does not believe basic structures. And that brings me, we've talked about will of the people, we've talked about what is the rule of law. So I talk about the basic structure. He's entitled, as I said, he's entitled to his view. But I'm rather surprised, if not shocked, that 49 years or almost 50 years after Keswanandan Bharti's case was decided, and there have been a number of judgments after that, Minerva Mills, IR Kohodo, then the NJC case, and many others where it has been established that the basic structure doctrine is very good for the country. A voice is not being raised that this basic structure theory goes against the Constitution. You all have read a little bit of history. In 1933, Adolf Hitler was elected to be Chancellor of Germany. He was elected by popular vote. Please remember that he was elected by popular vote. Germany had a constitution known as the Weimar Constitution. And that constitution had a provision, like ours, that constitution can only be amended by a two-thirds majority. In our constitution, we have another procedural safeguard, which is that in respect to certain constitutional amendments, the 50% of the states also have to ratify this. Now, what they did was, using their brute authority, they made so many amendments that they took away the rights of the citizen. Hitler used his brute majority to change the entire constitution and take away the rights of the citizens, including the right of freedom of speech, association, residence. You know, we think of residence, Article 9 talks of residents who can live anywhere in the country, and habeas corpus. They also passed a law. The parliament passed a law that hereinafter you don't have to bring anything to parliament. Executive, we delegate our power to the executive to now pass any laws, and the executive doesn't have to follow this two-thirds majority or anything. Why should they follow? They're the executive, they'll do. And we know what happened in Germany. Millions of Jews belong to a minority community were killed in state-run pogroms. The Holocaust is something which should never be forgotten. As an adult, I've been to two sites where tales have been brought to my eyes. One is the Andaman cellular jail, when you visit and see what your freedom fighters have done for you. And the other is when I read anything or visit anywhere concerned with the Holocaust, which took place against the Jews. So when Germany, after the Second World War, when the Federal Republic of Germany that is West Germany, was drafting its own constitution. They said we'll have some basic clauses which can never be. So from clause 1 to 19.1, if 20.9, sorry, from article 1 to 20.9 of the new constitution, which included the principles of federalism, democracy, rule of law, separation of powers, fundamental rights, they were taken out of the amending powers of the constitution. They said these basic laws are eternal, they will live for eternity, and nobody, no will of the people or nobody can. Now, one of the great legal minds from the academic world who talked about this basic structure theory was one Professor Konrad Dietrich from Germany. And in 1965, he was asked to deliver a lecture at the Banaras Hindu University on this issue of the implied limitation on the amending powers to the Constitution. So he spoke about the German experience, and he argued that even under Article 368, though the power to amend is there by two-thirds majority, the Parliament cannot amend something which is very basic to the Constitution. Now his paper was published. Very few people attend lectures by academics. I'm lucky that today the hall is full, but normally I address empty halls half the time. But his paper was published, and a very great constitution lawyer of those times, Dr. M.K. Nambiar, got that paper. His son, Dr. Nambiar's son, is Mr. K.K. Venugopal, who was just the former Attorney General. So, Mr. Nambiar, when he argued Golaknath's case in 1967 before the Supreme Court, did present Dr. Conrad Dietrich's paper and argued on the basic structure of the Constitution. In Golaknath's case, the theory of the basic structure of the was not accepted, but it was not rejected also. And they said there is force in this argument, but we will see it in a better case, on a better patent. थोड़ी सी reluctance होती है to look at a foreigner for advice. But in 1973, when Keshavanandan Bharati's case was being argued by the most brilliant lawyer this country has ever seen, Mr. Nani Palu, not only a brilliant lawyer, but one of the greatest humanists this country. The most gentle soul, unassuming, humble. When Mr. Palkiwala went to address, he, according to Mr. Fani Nariman, he did not carry any books with him. He did not carry any case law with him. He only carried one paper, which was the paper of Conrad Dietrich. And with that paper on the limitation on the amending powers to the Constitution, he succeeded in case on. And that is where the theory of basic structure became a doctrine and a part of our judicial system, our jurisprudence. But there's an interesting, I was talking to Mr. Fani Nariman one day, and he said, no, it is not Conrad Dietrich who is the author of this. He said, actually, Justice Cornelius, Chief Justice of Pakistan, in 1963, used the, he didn't use the word basic structure, but also said that the Parliament had no power to remove a fundamental feature of the Constitution. It's a similar thing. This was said in first of all, Father Chaudhary versus Muhammad Abdul Haq in 1960 by the Pakistan Supreme Court in 1960. And this view of the Pakistan Supreme Court was found support in the Indian Supreme Court in Sajjan Singh's case, which you are all well aware of, where Justice Madhorkar referred to the Cornelius, Justice Cornelius' judgment and said that this is a basic feature of the Constitution. So this is a mixture of ideas. Maybe for all we know, Justice Cornelius may have got it from Conrad Dietrich also. We're not sure. But what will happen if we do not follow the basic structure? If we say the will of the people is supreme and you can change everything and you do not even have to bother about the basic structure, then Parliament can say, we remove sovereign from under preamble. Parliament can say, we divide this country into four. Parliament can say, we do not want this country to be a democracy. Let it be a monarchy, or worse, a dictatorship. If the basic structure theory is not there, then with 2/3 majority, Parliament can say, we take away all the fundamental rights, or abridge them in a manner which makes them unenforceable. Parliament could delete Article 32, or worse, could delete Chapter 3 dealing with the fundamental rights. Parliament, by a majority of 2/3, could remove Article 13, which says no law can be against the Constitution, or can remove Article 14, which promises equality to all. Can this ever be the will of the people? The answer has to be in check. Therefore, Parliament, even if it represents the people, cannot change what is the basic structure of the Constitution. It is now an integral part of our jurisprudence. And no doubt, Constitution must change over time. Constitution must also be dynamic. We have to keep with the changes. But there are certain core values, certain basic values, what the West German constitutions, or now if the German constitution says, what are the eternal values, they never. Now coming last to the political system. If anybody has seen any of my articles or something in the recent days, I myself am not a very great fan of the political system as it stands today. I myself feel that it requires a lot of improvement. It has to become more objective. It has to become more transparent. However, with all these shortcomings, I do not see a better alternative. It has been said that some of the best judges, including Justice Adaltullah, were appointed when the government had the power to appoint and there was no political. But around 1950 to 1973, if you look at the history, you will see that all names sent by the Chief Justice of a High Court were accepted by the government. There was never a difference of opinion. Because I'm not saying even the Chief Justice never thought of caste or this or that. They also never thought of giving the juniors a representation on the bench. It was made on merit. Obviously, merit also has its different connotations. And the government never disagreed. It was in 1973 when this famous Keswanandan Bharti case was decided that the top three, that is Justice Hegde, Justice Sharath, and Justice Shah, were superseded, and Justice A.N. Ray was appointed Chief Justice of India, the other three judges. Then started the interference in the judiciary, because the then Law Minister, Mr. Kumaramangalam, said, we want to pack the courts with judges who understand our field. I'm not quoting, but basically this is what he said. Now, then the tussle started. And the emergency was the darkest years for this country. Those of you who have not seen the emergency must read about it. I was a student of law when emergency took place. I've seen some aspect of that. Those of us who have seen the emergency never want to go back to days like that. Yesterday I was on YouTube listening to an old interview of Ali Nariman, and he talked about the days of the emergency, and he said that there were two stalwarts of the bar, C.K. Daftari, who was a former Attorney General of India, and one Chandu Mane, who was one of the senior-most lawyers. And they both, Desai, one Ashok Desai's father, right, forgetting the name. So they were both came and sat down in the bar room. Justice Mr. Daftari lit his pipe, and the other man, Mr. Desai, also lit up a cigarette, but they were both quiet. The other gentleman says to Daftari, Chandu, kuch bolo na. He says, tum pehle bolo. Those were the days of the emergency when two close friends would also not talk, not wondering that if I say something wrong, I may be behind bars. And these were the top lawyers of the country. We don't want to go back to this. No doubt, some may argue that the collegium has been brought in by constitutional judgment. It does not find place in the constitution. But you must remember the background in this picture. Judges were being transferred, inconvenient judges were being sent back. And therefore, we had the spate of the three judges case, S.P. Gupta, and the last ending in the reference to the Supreme Court of India. During the emergency, we had another famous or infamous habeas corpus. V.N. Shukla was State of Madhya Pradesh. State of Madhya Pradesh was V.N. Shukla. 9 high courts. You know, people say the emergency, the judiciary is the darkest time for the judiciary. In a part, I agree with the part. The Supreme Court reached its nadir, the lowest point during the emergency. But people forget the role of the high courts. 9 high courts in this country, 9 different high courts in this country had held that even during the emergency, whether external or internal, you cannot take away the fundamental rights of the people. It was the Supreme Court with a majority of 4-1 in this case who said otherwise. So it's not the entire judiciary. And again, going back to Mr. Fali Nariman, he has a very interesting theory. He says in 1975, the Supreme Court was a small child, only 25 years old. They had no history. Whereas the high courts like Bombay, Calcutta, all had an existence of 100 years. So they were established courts and they knew how to handle the executive and the legislature, whereas the Supreme Court was unable to handle the responsibility which fell. Another argument in the collegium system is that in no other country do judges appointed. The idea given is as if in India judges appointed. It's not correct. When the High Court collegium, 3 judges of the High Court recommend a name, it goes to the state government. The state government looks at the name and sometimes does not agree with the High Court collegium at all. Then the names go to the Supreme Court collegium as well as the law ministry. It is not as if they don't go to the Ministry of Law. An IB investigation, an investigation conducted by the Intelligence Bureau on the integrity of the person concerned. And those inputs are then given by the government to the Supreme Court collegium. And I can tell you a very interesting IB report. Do we have time? Yes, it will be running also. So IB reports can't also be very. I know of instances where it's been totally wrong. But it is not that the government doesn't have a say. And many times the collegium accepts what is said by the government. The difficulty only arises when there is disagreement. And that disagreement doesn't happen very often. It happens sometimes. Recently, there have been 2 cases of disagreement which have come out, which the collegium has now put out in the public domain. One is of Mr. Saurabh Kripal, who is openly homosexual, who has never hidden this fact. His name was recommended more than 5 years ago. Nobody denies his competence. Nobody denies his intelligence. Nobody denies his integrity. But his sexual orientation was reached. Second was that his partner is a Swiss citizen. There are many people holding high posts whose spouses are not Indian. To name one is, I respect a lot, and I think he's one of the finest ministers today, Mr. S. Jaiswal, India's Minister of External. His wife is of Myanmar. I think if I'm not wrong, Japanese. So that cannot be a ground. But worse than that, even worse than Saurabh Kirpal, is the case of the gentleman from Madras whose name was recommended for the Madras. Chennai is where Dr. Ambedkar belongs. Now his name was elected on what ground? That he had shared in the social media an article which was critical of the Prime Minister of the country. We are talking of a democracy where dissent is an inherent part of a democracy. Anybody has a right to criticize the policies of the Prime Minister. And he has not done what? He has shared the article. He's not even the author. In my view, even if he was the author of the article, that could not have been held against him to hold that he is unfit to hold that post. What does it show? What does this show? This shows that they want to pack the court with men and women who will toe their line, who will not be critical of them. And if they will not be critical of them, they will uphold every action which they will take. Now, is this a judicial duty? Therefore, young ladies and young gentlemen who are going to enter the legal profession in a year or within this year or two, I mean, a fervent plea to you, do not let this vision of Dr. B.R. Ambedkar and the founding fathers of this country be besmirched. It is you have to fight for your own rights. But you not only have to fight for your own rights, but you have to fight for the rights of your brother and sister citizens who may be marginalized or underprivileged and may not have the means to stand up for themselves. It is my request and plea to you, don't let the heart and soul of the Constitution of India die. Keep it eternally alive. Do not let anybody tamper with the basic structure of the country. No doubt, no system is perfect. There can be no doubt. There is no perfect system. You, the young students, are the leaders of tomorrow. India will be in your hands. If you remain vigilant and protect your rights and work with the view to protect the Constitution, nothing can go wrong in this. I end my address with a quotation again of Dr. B.R. Ambedkar. This is his last lines when he was addressing the Constituent Assembly on 26th November 1949. I quote, I feel, however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good. The working of a constitution does not depend only upon the nature of the constitution. The constitution can only provide the organs of the state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties, and they will set up as their instruments to carry out their wishes and their politics. Thank you very much. Yeah.
Thank you, sir, for delivering such an engaging and inspiring lecture. Indeed, the statue of Dr. B.R. Ambedkar, which is installed adjacent to the library, is a constant reminder of our duty towards ensuring a just and fair society for our fellow citizens. I hope the lecture has left the enthusiastic brains of the audience occupied with questions. Sir, with your permission, we shall proceed to take a few questions from the audience.
Good morning, sir. My name is Mazum. I'm currently sir, my question pertains to the fact. So, when we talk about will of the people can be exercised in two particular aspects. One is will of the people when it is exercised directly. And take the example of the recent hijab case which happened in Karnataka, where there is exercise of will of the girl students in terms of the fact that they want to wear a hijab to college. And the other aspect of exercise of will of people is when it is exercised through legislative lawmaking, when it is exercised through lawmaking, when the parliament makes a law, and it is in that law that the Supreme Court gives it a sense of deference when it comes to judicial review. So, in that aspect, taking the example of the evolution of the essential religious practices doctrine, based on which the Supreme Court and the High Court had adjudged the hijab case to a certain extent. The question is that we have seen over the years with the evolution of the essential religious practices doctrine that the Supreme Court has, in Shirinma judgment and then Shaira Bano, significantly held that the essentiality of religion is to be determined by the people who are part of that religion. Even with the limited judgment that was in the Shairamano judgment when Rohitan Nariman said that, okay, you have to test it directly on Article 14. But even then, Justice Kurian Joseph held to a large extent that the test is basically looking at how religion, how the people who are part of that religion adjudicated themselves. So in that sense, don't you feel that the Supreme Court over the years has has insisted on a certain amount of deference when it comes to adjudicating cases on the exercise of will of people that comes directly from the people, as opposed to the will of people when it comes through Parliament?
I think I slightly disagree with you on one aspect. That what is being exercised by the people, either by wearing a hijab or exercising some religious practices, is not the will of the people. That is the right of the people. There is a difference between the will of the people and the right of the people. Now, I have my views on hijab and all, it's a very long. But you see, because I feel that cannot be called the will of the people. Because that's the right of certain parts of the society. I have my views on hijab. I personally am not in favor of the hijab. But I also feel that if somebody wants to wear the hijab, there's nothing wrong in that. And then we'll see how the Supreme Court decides that. As far as coming to the judgment in Shaira Bano's case, it's a long judgment. You see, that's the problem when all judges write different judgments. Then becomes the problem. You don't find what is the ratio of the judgment. But see, what Justice Nariman held was that there are certain things like I don't agree with him. Let me be honest, I don't agree with him because I personally feel judges are not suited to decide what is an essential religious practice. That has to be decided by the community, etc. And judges can at best adjudicate upon it whether it violates the basic structure or the fundamental rights of it. So that is my view, but I'm in a minority, let me tell you. Judges hold the different view. Thank you.
So, sir, thank you for gracing this occasion and coming to HNLU. I'm Yash from Tech India. And so my question is particular to the remark by Justice Pardiwala in the recently held EWS reservation judgment, that is the Janat Abhyaan Union of India. Sir, when we look at the basic structure doctrine and combining it through the lens of rules of law and will of people, the successful instances where the basic structure doctrine has received the assent of the people and popular support have been of the judicial independence, that was of Indira Gandhi and the Rajnaran case, then there is Keshwan and Bharti, Minerva bills, etc., etc. Sir, Justice Pardiwala qualifies it, and I quote him. He says, the repeated use of the doctrine of basic structure may impair the doctrine itself, and it is likely that the idea of constitutional essentialism might not get the respect it deserves from the political institutions such as the executive itself. Sir, furthermore, I'd like to endorse and cite Professor Satya also, who has again written, and he has also been quoted by Justice Pardiwala. He says that the in unresponsible use of this doctrine may severely threaten the culture of this doctrine and the support it receives from the people. So my question to you is, going back to the four judges case, where Justice Kher remarked that collegiate system does require changes, how does the judiciary circumvent such changes in light of the Justice Pardiwala's opinion that if such unresponsive use would not allow the basic structure doctrine and the institutional judiciary to command the same respect as it has commanded till now? And so the same has been observed by Vice President's remark and all of the tussle that has been going on with the judiciary and the executive. Thank you, sir, and I'll be more than honored to have your remarks upon this.
Thank you. I think there's a difference between what Justice Pardiwala has said and what the Honorable Vice President has said. There's totally different. The Vice President said that he questions the very validity of the basic structure. Justice Pardiwala has said something else. It's a word of caution that don't use the basic structure theory in every case. So what he has said is that if you overuse the basic structure theory, then the chances of the theory being diluted are very high. So he is respecting the theory, but he says in every case, you see, some of us have this habit. The basic structure theory is only to be used on the constitutional ground. When there are issues like that, it is not to be used in deciding every case. So, but having said that, I may not totally agree with him on that also. If the basic theory, basic structure theory is applicable to a particular case, because that takes EWS reservation. Now, whether it violated the basic structure or not is a different issue. But it was a case, I think, where the argument was very germane. It was not the argument because it was absolutely new, sir. Otherwise, our constitution did not recognize reservation on the basis of economic basis. This is by constitutional amendment which has been done. So why should it not have been argued? I don't agree with you.
So if there are few more questions, my request is that the question should be shorter than the answers.
Good morning, sir. And I'm really sorry, sir. This question is also going to be a bit too long.
I think what Dr. Vivekanand is saying, don't express your opinion. Just give a question. You see, it doesn't have to be what you think and all. So put it in a question form, I'll answer.
So first of all, thanks for coming here. I'm in fifth year. I'm Vikramaditya. So basically, I'm cradle of legal education. And like you said, the constitution is the Gita or the Quran. So for us, the Supreme Court and the Parliament have Makkah and Medina. So for a person who has manned those institutions and sitting here, I can't resist myself from asking a very fundamental question. So whenever we look at the aims and objective of any NLU, be it HNLU, the objective has been written to promote legal individuals to take up advocacy and judicial service. But what is actually happening on ground? For example, if I take my batch, the top 5 rankers, 9 are opting for corporate service, 1 is going for MBA. Not even a single person is ready to take up advocacy or the judicial service. So we are talking about reform from the top, that is the collegiate. But we are neglecting the lowest, which forms the base, the lower judicial services. So no one is interested. And no one is interested to take up judicial service. And the same is the case with each and every MLA. So are we missing out on something? And why the All India Judicial Service still remains an idea? Because when you look at the side of the executive, the All India services are able to attract the best minds from the IITs, IIMs, and AIMS. But no one from NLUs are ready to take up the judicial service. So what is the major hindrance in taking up the All India Judicial Service? Or is there any other way by which we can attract individuals to the judicial service? So because when we talk about the High Court and Supreme Court, that's one thing.
No, I think I've understood the question. If you answer the question for me also, then it will be a bit difficult. See, 2-3 things. First of all India Judicial Service. It can't be done with the consent of all the high courts in the states. And most of the high courts are not agreed. For whatever reason, I won't get into that. It's not very easy. You see, it's not like this. Every state has its own laws. It has its own language. Sometimes it's very difficult to But I myself have always felt that we should have, at least at the district judge level, an all India judicial service. This has been my view. Go at the subject. Now coming to the second part, why are people wanting to become IS officers or IPS officers and not judicial officers? Let me tell you, young man, Vikramaditya, your name is? Let me tell you, Vikramaditya, that the salary of a subject today at the entry is higher than that of an IS. So it is not the salary which is the attraction, it is the power with the IS officer. And it's more, unfortunately, it's more the unconstitutional power with the IS officer exercises the attraction. Now, when it comes to, I would be very happy if more people join practice, litigation, and not corporate. But I have understood, I've talked to students and I understand the difference. Some of them have taken loans to, study in the NLUs or other law colleges. They do not come from very good backgrounds. Unfortunately, law is a profession where you don't get paid well in the beginning. You get paid nothing actually in the beginning. And for 3-4 years, you have to really fend for yourself. So this attraction of going to corporate world or going to other. But I don't think it's totally right. I know of a number of people. In Himachal, I've had 2 people from the from Bangalore who joined us sub-judges. So one resigned later on for a very different reason. It's not that nobody joins. In Delhi, we have a lot of people from the NLAs who have been practicing in the High Court and the Supreme Court. We find it, but the basic reason is not that they don't want to, but because economic reasons force them not to join practice. So I don't know, that's a very personal choice. अब किसी के फादर लॉयर है तो वो बन जाता है बिकॉज उसको पता है कि 5-7 साल के लिए तो रोटी पानी मिल ही जाएगा ना. The other person has a difficulty. I don't think we can just, yes, we must make an attempt and the seniors must. The Chief Justice of India, Dr. Dhananjay Chandrapur, said this also recently, that seniors must pay the juniors better. There should be a better working environment for fresh inductees into the law. And that's how we get fresh talent. But there's no shortage of talent. I can tell you, when I joined law as a student in 1975, जिसको कई जगह एडमिशन नहीं मिलती थी, वो law करने जाता था. It was the last resort of the scum. Today, it's the first choice for some of the best students. Everybody sits for the CLAT examination. So why is that? So I don't know. There is, what you're saying is not totally wrong. But why I have no answers. I have no answers for some of it. I've attempted to answer.
So I really don't want to restrain the enthusiasm of
No, that's up to
the audience because it's actually the credit of the speaker. The speaker is frank and dynamic in answering. There'll be more questions, I know that. But I would say there are a few more, 1 or 2 more we can take. As I know, the difficulty of structuring question is an art, right, which you practice. So that's very important for lawyers. They don't have much time in the court, right, where they have to convey a few things. So we want to still open for questions.
So if
Yes,
so,
problem.
which we can take.
5-10 minutes, no problem.
Another 10 minutes more.
No problem.
My flight is at 2 o'clock.
Sure, sir. We'll proceed with next question.
Thank you so much, sir. Good morning. This is Shruti from second year. My question to you is
I
that
didn't get your name, sorry.
Shruti from second year. So in your speech, you mentioned that you do not agree with the current political representation of the will of people. So my question to you is, what is your suggestion for the real representation of the will of people?
It's really short and sweet. No, that's a perfect question. And I'll give you a short answer. I don't know if it's sweet, but it'll be short. What I said was that it doesn't represent the will of the people. But I also said that this is the best form of democracy. I don't see any other system. One universal franchise, there can be no better system than. But whether it represents the will of the people to alternate the bill, to amend the basic structure, there I say that it is not. I don't say it's not the will of the people. It's the will of the people, but when we talk of will of the people in the context of the present debate in the country, will of the people, basic structure, collegium, I'm talking about that. Mine was limited to that. Thank you.
Thank you, sir. We'll be taking one more question if there's any.
Hello. Yes, am I audible, sir? Yes. So my name is Mukund and I'm in my fourth year. So when we look at the question of, and when we always view this question of will of the people and rule of law, we have always seen that from the tussle point of view. My question is basically, can the will of the people be used to add a facet to the rule of law? As in, can the legislature, as a popular government, add a facet to the basic structure of the constitution? In the sense that this question of basic structure, the theory always emanates from the fact that the constitution makers always contemplated certain essential facets of the constitution, which, though were not explicitly mentioned, have always been to be the spirit of the constitution. Now, can we say that the legislature, be it a popular government having more than 50% of the votes of the people, can we really say that they can add on like a facet to the constitution? Just to exemplify, sir, can we say that, say, the 10th schedule, the anti-defection law, is part of the basic structure? That facet was not originally and not contemplated originally by the constitution framers. That is only added later on, and that is also a tool which is being used to protect a facet of the basic structure, namely parliamentary democracy. It's tenuous parliamentary democracy. So can we say that the will of the people can be utilized to add on, to really strengthen the rule of law in the sense that it can really add on to the basic structure? Understood.
See, there can be no doubt, please sit down. There can be no doubt that Parliament can amend it. It can also amend what is the fundamental rights. The Kesavanandan Bharti, though it had basic structures theory, but it upheld the validity of the law. People forget that. Basic structure, they said something else. But as far as the law was concerned, they upheld the law. It was not that they struck down the law. Now, what? See, we are a country of 135, 140 people. If we all work for the betterment of the country, then nothing which comes in the way. So if the amendment is to be made to improve the constitution, add something to the basic structure, I see nothing wrong with it. That cannot, it's not the basic structure itself is inviolate. But there are certain values, what I talked about the Weimar Constitution. When they said Article 1 to 20.9 will not be violated, those they say are some eternal values, democracy, rule of law, separation of powers, an independent judiciary. These, if you touch them, fundamental rights, freedom of speech, you can have restrictions of them, but you can't take them away from you. So these are inviolate. You can't violate. That is the theory of the business. As far as I have a little disagreement with you with regard to the 10th schedule. First of all, it is not part of the business. It is something to prevent defection. And I think the way it has been worded, it has caused more harm and damage to democracy than, I'm not saying that was the intention. The intention was to prevent defections, but in the end, it has ended up causing more harm to the system. And that is why a lot of call is going on for making changes in the country.
One last question.
Yes, this lady young here.
Good afternoon, sir. This is Ayushka from first year. And my question is, what's your take or view on official language of the court? As it is said that Supreme Court and High Court proceedings will be in English language. And we know most of the population is not exposed to the language, they do not know the language. So what's your take on this?
See, there are two parts of it. We had a Chief Justice before me, Justice Jatin Singh, who used to deliver judgments in India also. And it's not that in this part of the country there are lawyers and judges who argue in Hindi. I've never stopped anybody from arguing in Hindi. But unfortunately, I started in writing in English medium from the beginning. So very Hindi बहुत अच्छी नहीं. So I feel uncomfortable when judgment need to take place. But what you say is right. Finally, the courts must be, the judgments must be simple. And that is an attempt I've always made as a judge, that my language there, I used to say that my judgment should be in such simple English that anybody who studied in up to class 10 in a government medium school can understand. He may not be able to understand the legal issues, but he should be understand what has happened. So, हमारा consumer तो finally it's the litigant rules are consumed. If he or she can't understand what has been written by the judge, it's a sad. So I think the time but the change can't be over. You see, the problem will also be in a very diverse country like India. The day you say कि Chhattisgarh में it will be in Hindi, somebody in Tamil Nadu will say we will do it in Tamil only, and somebody in Kerala will say it will be in Malayalam only, somebody in Karnataka say Kannada. You see, then what happens is that for judges who get transferred, and we have chief justices always from outside, they will end up doing no work if the argument is in their own. So, but finally, one day we will have to reach a stage where there is a good amalgamation. But I appreciate what you. Thank you.
Thank you, sir.
I think the faculty are a minority here. So one question from the faculty can be taken. And for the last question, it's just in a year's time this will be solved. There is something like Open AI or ChatGPT coming in. And as the judge is speaking, everybody listen. The mic with different languages in the same room, right? So technology could inform.
I did not prepare my lecture on GPT.
I don't. So that's not a major thing. Technology is going to solve this, in my opinion. More than it's a matter of language, of understanding. But the big challenge is not the language you deliver, but the language you apply your mind. Then come to a judgment. That seems to be the biggest challenge.
Thank you very much, sir, for giving me the opportunity. So actually, the government is nothing but will of the people. I feel like that. So in recent cases also, when the Supreme Court ordered the government to have some sort of transparency with regard to the appointment of election commissioners. So when election commissioner was appointed, single election commissioner, he was Sheshan. So the government diluted the system of the election commission also. Again, they made it two election commissioners to take the power in favor of the government. So now the government wants to send the representatives to the collegium also, where it is confidential. So what is your opinion in this? Whether you wish to invite the government representatives to the collegium or not? Please.
I don't know where you got this from, but Mr. Rijiju has very clearly said that he does not want to send any representative to the collegium. But he says we want to have a voice in the collegium, not by a representative. I have said this on more than one occasion. I've said it 2 days back in an interview to NDTV and also to India Today, that I do not believe that the government should totally be shunned away from the process of selection of judges. In fact, I believe that somebody from the government, you see, in most cases you don't have to have this. Where the agreement takes place, where name goes, the government approves, there's no problem. But where this is disagreement, it is better that the law minister or his representative choose. They sit with the Chief Justice and the collegium once in 15 days or once in a month. They sit together. Many things, when judges are being appointed, cannot be said in them. When you're commenting on a sitting Chief Justice of a High Court, or when you're commenting on a very senior advocate practicing in a High Court or in the Supreme Court, sometimes you can't say everything in writing. Even the government's point of view can be sometimes explained more orally than in writing. I am in fact in favor of a direct talk between the government and the members of the collegium. Because otherwise क्या होता है? Indirect pressure पड़ते हैं. 4 to 3 collegium के member हैं या 5 हैं. So one will get a call from the law minister or some other person. कि please help him, he's our man. It is better that they sit across. Because I personally feel nothing wrong. See, if you read Justice Chawla's book, Roses in December, he used to say he and Morarji Desai were totally opposite poles. Morarji Desai was a prohibitionist. Justice Chawla used to like to drink every evening. And he used to say, I broke the prohibition law every day. He said, I was a hardcore non-vegetarian. The only day I had vegetarian food was when Prime Minister Desai, who was in Bombay State, it was earlier Prime Minister, not Chief Minister, then Chief Minister Morarji Desai, came home and had food with me. आपस में dialogue करने में कोई गलती नहीं. I don't want them essentially as a member of the collegium, but their voice should be, the government has a strong voice and should be heard even by the collegium. And if merit is the only consideration, अगर सब बाकी भेदभाव छोड़ दो और मेरिट ही देखो तो क्या आपको इतने सारे कॉम्पिटेंट जजेस नहीं मिलेंगे? आई थिंक यू विल फाइंड मोर देन इनफ कॉम्पिटेंट.
Thank you, sir. And I thank everyone for this very engaging session. May I now request Honorable Vice Chancellor V.C. Vivekanandan, sir, to present Honorable Mr. Justice Deepak Gupta with the memento as a token of appreciation for his valuable presence today. Now, I request our respected registrar, Professor Uday Shankar, sir, to present Honorable Mr. Justice C.B. Bajpai with the memento as a token of appreciation for his presence.
May I now invite Professor Dr. Uday Shankar to deliver the vote of thanks.
Greetings on the occasion of Public Day. For every institution, founding an inspirational trait and a legacy to follow is the mandate. In the year 2022, the university has installed the statue of Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, and started a memorial lecture for celebrating his immense contribution in shaping the destiny of the country and of the people. We are thankful to Honorable Justice Deepak Gupta, former Judge, Supreme Court of India, and former Chancellor, HNLU, the affiliation which all of us remember and cherish, for delivering the second edition of the memorial lecture on will of the people or rule of the law. Constitution symbolizes rule of the law. Government symbolizes rule by law. And sir has very appropriately said that any understanding of will of the people by rule by men should be discarded. So thank you for gracing the occasion and sharing your thoughts on this very important topic which is being discussed in today's context. We also extend our heartfelt gratitude to Honorable Justice C.B. Bajpai, former Judge, High Court of Chhattisgarh, and former Vice Chancellor officiating. Sir, thank you for traveling all the way from Glasgow and sharing your thoughts on this day. Let me also take the opportunity of thanking our Honorable Vice Chancellor, Professor V.C. Vivekanandan, who always guides us, motivates us, and encourages us in all our academic endeavor. So thank you for giving opening remarks. I also place on record my appreciation, gratitude, and thanks to the deans, faculties, staff, and our students for attending this memorial lecture. And I'm very sure what you are going to carry back is a lovely memory and also a kind of resolve to commit to the values of the Constitution. Lastly, let me thank the support team, the IT team, and all other
support team for making this program a successful. Thank you. A very good day.
Thank you, sir, for those words of gratitude. I would now request the dignitaries and the faculty to kindly proceed towards the stage for the group photograph.
People can stand here also.
Yes, yes.
So that we can manage everybody.